Okay, so I think it's time to start session one, Emergent Trends on Permanent Establishment, Business Nexus and Profit Allocation. I'm Pasquale Pistone and I'm delighted to be here and support this group of colleagues who's bringing together academia and practice on matters of international tax law. I hope that my presence here today shows how much supportive I am. I should say that the work done at the Belgrade conference is serious research, and I'm sure that serious research will come out of this meeting too. I'm happy to co-chair this panel with Mario Tenore, and as you know, we have one speaker missing, and that was already mentioned by Professor Allena. So Anna Luigia Cazzato is not here for personal reasons, and we couldn't find a last-minute replacement, as Marco Allena said, so apologies for that. We have taken the liberty of having two co-chairs to turn one of the two co-chairs into a member of the panel, so that gives us also more possibilities to interact and to have more issues to discuss. This session starts with a keynote speech. So the keynote speech will be different from the panel presentations. So we have allocated more time to the keynote speech, and we're glad to have with us John Peterson from the Center for Tax Policy and Administration of the OECD. I think that it is particularly important to hear the voice of the OECD on a topic which has been the object of significant attention by the OECD for a number of years. And of course, some of the issues that we should consider also within this panel have already been mentioned by Philip Baker in his introductory speech. That also facilitates my own introduction, which I will keep to the strict minimum, also because I will be interacting and making comments with the other speakers. I think it's important for us to understand that the concept of permanent establishment belongs to the tradition of international tax. It has its own legitimacy in the so-called brick-and-mortar economy, and this is something which has played an important role for a number of decades, I should say, or over a century. But now the issue is really understanding whether it's fit to meet the challenges the current shaping of the economy. And you know, my personal view is that, and I have put it already several years ago in an article that I co-authored with Peter Hongler, is that before deciding whether we want to get rid of the concept of permanent establishment, we need to make sure whether there are possibilities to adjust the concept of permanent establishment to the current scenario. And that is something which pretty much relates to the understanding whether the physical presence is something strictly needed for the core notion of permanent establishment. Now, there have been considerable developments since the time that I wrote that article with Peter Hongler, and we have seen the development of the significant economic presence concept. And this is something which also has prompted some countries to come up with more specific implementation of that concept. And we will hear also from Mario Tenore about some of the issues that arise in connection with domestic Italian tax legislation. But I think that before doing that, it's really important to understand what is the current work and what are the current challenges at the level of the OECD. And we will hear them in the next 30 minutes from the voice of John Peterson. So John is now 9:26. You have the floor.
Thank you very much, Pasquale. And look, let me start, I guess, with some points I think where we're in common agreement. The first one I think is it's clear that the current mechanisms we have for taxation of permanent establishments do not work well in the context of these large global M&Es. Which generate significant profits and use digital technology and global supply chains to operate, and as such do not require, as you were saying, Pasquale, any physical presence in the jurisdictions where they are creating the value. And I think that we all agree that and we've been having this discussion now for well over 10 years, at least in the OECD context, while I have been there, and we are continuing to wrestle with this problem today. But the problem is real, and it's not going away. And let me also agree with Pasquale that by and large, however, the existing system that we do have works tolerably well for the vast majority of businesses. So there is something that we need to do here to address the new challenges, but that does not involve necessarily us revisiting the entire structure of the tax system just to fix what in one context is a particular problem. I think it is worthwhile pausing on the fact here that we have been working on this problem at the OECD at least since the beginning of the BEPS project, specifically in regards to the taxation of these large global digital businesses. Starting with the Action 1 report, and most recently with the progress report and now the outcome statement, and we are working diligently towards the release of a multilateral convention. And
John, I assume you want to share your slides with us because we cannot see them at the moment.
You cannot see them. That is
so maybe you want to share screen.
Thank you. I have done that, but I shall do it again and see if this works again.
Now we see you.
Does that come through?
Yes.
Excellent. Okay. So if you go back to the BEPS Action 1 report, we wrote a report that said, look, you can't distinguish between the digital economy and the non-digital economy. The economy is digitalizing, and so we need a solution here that does not ring fence the digital economy. We then, through the process of the dialogue that we were having in the context of the inclusive framework, there was an interim report that we did around 2007, where the conversation had shifted. We were focused then on user contribution as an idea, and we even set out in that interim report an interim measure in relation to a sort of a proto-digital services tax. Then we go out of that into a program of work where we are now confronting the fact that we are going to have to come up with a new allocation of taxing rights and new profit allocation rules in relation to these businesses. And when we produced the blueprint in 2000, around 2000, wasn't it? We actually have now developed a profit allocation mechanism, but it's focused on ADS and consumer-facing businesses. Then you get to the progress report of Amount A, and the scope has changed. It's now sort of large, globally operating businesses, and we're not trying to focus particularly on particular types of business or value chain delivery mechanisms. And so throughout that 10-year process, you can see an interaction that's taking place in a multilateral context as we try out different concepts and test the complexity of those projects and test them in the context of a multilateral environment where there are different views on the table and compromises must be reached in relation to that. And if you take the overarching arc of the work that has been done in the space, I think you can see evidence of both detailed thinking and multilateral thinking around how it is that we're going to collectively attempt to solve this problem. So what we have here is an evolving picture. It continues to be an evolving picture. We have a picture here that's based very much on multilateral dialogue, tempered by the fact that obviously we need to reach a consensus on this. And I also think that this is an issue clearly that is not going away. So if we have any sense in which the answer that we arrived at is not the right one, the answer is that we can't simply turn back the page and go back to where we were, because that is not going to solve the problem either. What I want to talk about is a little bit more detail now about the structure of Amount A. As you will be aware from the outcome statement released in July, we are working on the release of a multilateral convention. It's going to be a big document. I won't lie to you, and there will be much to pick at, I expect. And it's always easier, I think, easier perhaps I would say, to pick a paragraph or a feature of these rules that one does not like, and write an article on them than it is necessarily to get to agreement on the same question in the context of these multilateral discussions. But if you start with what we are trying to do here in terms of answering the brief that has been given to us by the inclusive framework, which is that we now understand we're trying to allocate the profits of the largest and the most profitable M&Es to market jurisdictions. And that is going to be require us to come up with rules that have a certain degree of complexity. They're going to be novel. So we are going to build into that a tax certainty process, a rigorous tax certainty process to make sure that these new rules are not highly disruptive of existing business arrangements. And then as part of that, as part of the deal that will do that, we will remove digital services tax and other similar measures. And why is that? And that's because we firmly hold to the view in the OECD that we should be trying to design a system here for corporate income taxation that's based on net profit and that provides reliable relief from double taxation. Otherwise, we will create economic distortions in the system that will be to the benefit of no one. So the end product here is keeping net income taxation at the core of the system, but allowing a portion of that excess profits from those very highly profitable M&Es to be allocated to the market based on sales. So that is the project, that's the ask. And then if you then try and step into that and see what types of steps that you are going to need to complete that task, you can see some of the complexity emerging, but I think you can also see at each of those steps a relatively pragmatic and perhaps even borrowing from sort of Philip's comment, a formulaic, dare I say it, approach to how that could be done. So at step one, what we're going to do here is we're going to, and for most of you, you can look at your phones now because this is really not going to impact a significant portion of companies at the outset. We're talking about companies with 20 billion of revenues that are within scope, that have a 10% profit margin. And we also have carve-outs for regulated financial services as well as extractives. And I pause there because as soon as you have carve-outs in any system, when you're designing a system, carve-outs create complexity. You need to define the borders of those carve-outs, and you need to you regulate tax planning on the margins of that border. So we have tried to make those rules for carve-outs from extractives as simple as we possibly can. And we have backed them up with a ruling and a tax certainty process that won't simply apply just in one jurisdiction, but in all jurisdictions in order for determining the scope. And those carve-outs represent a combination of sort of pragmatic decisions about what's sensible in the context of tax policy design, together with, again, reaching a compromise in the context of a multilateral solution, which is what is needed here. So once we determine the scope, we then go and look at the nexus, and the nexus test is frankly de minimis for groups of this scale. It's very small, and in here you can see the interests of lower capacity, lower income countries being reflected, because we are not placing a heavy emphasis on the needs to achieve a certain volume of sales in a market jurisdiction. And in fact, the nexus test is lower for lower income jurisdictions. Then we need to source, once we've identified the jurisdictions where there's a nexus, we need to allocate this profit and proportion. We need to come up with sourcing rules and effectively an allocation key. And the rules are going to provide for a waterfall of different approaches based on data availability. With better data availability, justifying more refined sources, but the emphasis is always on making sure that we have consistent and a verifiable allocation of source taxing rights that makes sense from a design perspective. So again, doing something that is new here, allocation based on sales, easy to say, but what does that mean? What does that mean in the context of the sale of a component that goes into an iPhone that gets sold in a different jurisdiction? How do large distribution, wholesale distributors find out where it is that they are making sales in the market? What data sources are available to them? How does this work in the context of digital services where the purchaser of the service, the advertising service, may be different from the eyeball that sees it? None of these problems are in practice easy to solve. but the mechanisms that we provide for in the context of the sourcing rules are designed to accommodate the different business models that are out there, do that in a pragmatic way, rely on available data sets, and provide certainty. Once you've identified what the income sources are, you then move to the question of what profit are you allocating? And this profit calculation is a global consolidated profit margin. This is the first time that we have allocated global profits in the context of one of these rules. This is new, but it answers the ask of the countries in the room. So you start with financial accounts. There are limited adjustments that you need to do to the financial accounts because they're prepared for one purpose, whereas we need to use these for another purpose, but they are minimal. We need to account for losses. Losses are always the big problem in policy design because you actually want to account for economic income over time, not just within the context of the defined period in which the accounts have been set. And we need to adjust for MDSH, marketing and distribution safe harbor. This is actually a pretty complex idea, but it's important. It's important to get the rules to work sensibly, but it's also important in terms of both developed and developing countries and getting to the appropriate compromise on how this works. And what MDSH is doing, step 3 here on the final 3.4, what is MDSH doing is looking at when situations where, in fact, by operation of some kind of permanent establishment and allocation of profits, there is, in fact, residual profit in the market in relation to marketing and distribution activities, and therefore that there does not need to be an allocation in line with amount A because the existing rules are already doing their job. So again, I pause there and just think about the complexity associated with some of that thinking, the need for it as a pragmatic matter, and the needs to come up with pragmatic rules and achieve a compromise in relation to that. Because I think you can see that in a country that does and has secured large returns available to marketing and distribution activities in its existing jurisdiction, that it does not want to give those up just because it gets amount A. Equally, those large M&Es don't want to end up paying tax twice on the same income. Finally, once we have allocated the income, the global profit allocated out in accordance with where the sales are, our job is not yet done because we now have to come up with a mechanism for eliminating double taxation, fitting effectively the allocation that we have done, the global allocation done, back into the existing system, because by and large the existing system works tolerably well for a large amount of the transactions that take place in the global economy. So how does that work? Well, we need to effectively take that relieving obligation and allocate it to a jurisdiction that has that we identify as having that excess profit, and then we need to create a mechanism that gets the relief provided in that jurisdiction, or the economic benefit of the relief provided in that jurisdiction, to the entity in the jurisdiction where the tax is paid. So none of that is terribly easy either, but it's all necessary in order to make the system work. So that's at step 4. And then finally, and somewhat unusually in the context of the types of things we have done before, we need to build a single tax compliance process around this in order to drive tax certainty. So we have a single return, we have the documentation that is all agreed, we know what information needs to be provided. It goes through a multilateral tax certainty process, not only in relation to this new taxing right, but also the existing taxing rights in relation to the same activities, because effectively now we have a multiple base built on 2 parts. We need to make both parts of the system stable, otherwise we won't have the requisite degree of certainty. So that's the final step in the process, is doing the tax filing and certainty process. On a forward-looking basis, then, what happens if once we get the signature, once we get the MLC signed and ratified, is that countries then agree that they are not going to implement digital services taxes or similar measures. And ultimately, once the system has proved that it works and works well, there's an intention to lower the scope from 20 down to 10 billion at the end of 7 years. So in key terms, what do we have? We have something that is, I think, relatively simple to say what we are trying to do, right? We are taking the profits of the largest, the most profitable multinationals, and we are allocating a certain portion of those excess profits to market jurisdictions. Having said that, underline that there are a number of steps that we need to go through, and they are unavoidably complex. And the complexity there is inherent in the design of the system, but it also comes in part from the fact that we have, need to agree this is part of a multilateral solution. It's based on the need for consensus. So inevitably, some of these rules are arbitrary. If someone comes with one system and these people need to agree on how to design something, we shouldn't be surprised that we don't find any value in the answer they come to. The answer they come to represents a compromise between two sets of values. So there are necessarily arbitrary features in there, but those arbitrary features also are drivers of certainty associated with the process. And it's important to distinguish between the complexity involved in understanding these rules, and these are new rules, they are complex, and they will take time for those who are using them to get their heads around them, versus how those rules will operate in practice. And the various features of them that are designed to pick up from existing pieces of technology, picking up from financial statements with very limited need for adjustments, and the fact that this will be backed by a tax certainty process. In the net taxation problem, dealing with the net taxation problem, it's hard. And the solution, the answer could be, let's just go for gross basis taxation. But that is not the decision. It's not the decision that we have been charged with as part of our mandate, and it's also not a decision that we would believe in, because we firmly believe that we should be trying to make sure that it's the profit of these multinational corporations that are subject to tax and not gross income, because of the distorting nature that would have on the overall design of the tax system as a whole. I now move on in the time, I think in the time that I have available, very briefly just to talk about Pillar 2 in the context of permanent establishments and allocation. The point here is different, right? We're now looking at basically an alternative minimum tax based on an effective tax rate calculation, where you have a normative notion of a base and a normative notion of what counts as a tax. But this is an alternative minimum tax that applies in a global context. So in order to be fair, it needs to be ecumenical. It needs to accommodate the different designs of tax systems. And so when we look to the allocation of taxing rights to PEs in the context of Pillar 2, we're not really focused on where the income should be, because it's not that kind of normative. We're just really focused on the location where the M&E thinks it is, where the M&E has placed it in accordance with the existing domestic taxing rules that operate in relation to that income. That is what we're trying to achieve, something that basically tries to follow what the M&E has done, tests the effective tax rate on it, and then makes sure that it's subject to a 15% rate. So if you look at the way we treat PEs, these rules are located in Article 10.2 of the model rules. We have a number of different scenarios we look at. If you look across the slide deck, in the first case, we have what happens if there's a tax treaty between the source and the residence jurisdiction in relation to the PE. In that context, we would rely on the tax treaty because there's an agreed allocation of taxing rights between those jurisdictions. If there's no tax treaty, then we look to see whether the PE has been created under the domestic laws of the source jurisdiction. We look at the rules of the local jurisdiction to see how much of the income it is wanting to tax. If there's no CIT in the source jurisdiction, we apply the standard OECD model, because we don't have anything in the source jurisdiction that will allow us to determine the allocation of taxing rights. And then finally, in the fourth category, where you have a PE conducting its operations outside of the residence jurisdiction that provides for an exemption method in relation to that, we then pick up effectively that jurisdiction's taxing rules and say, okay, well then on that basis, the income that is exempt is in its own PE, but that PE is stateless because it's not being placed. There's no other domestic taxing right being exercised, parallel domestic taxing right being exercised over those same amount of profits. And so we put that into a stateless PE, and we treat that as being located in its own jurisdiction and tested separately for the purposes of the ETR calculation. And that's what you can see on the next slide when we talk about the allocation of income. Effectively, the financial accounting net income and loss of the PE is treated as being in the jurisdiction. In the first three cases, has been treated in the source jurisdiction, and in the final jurisdiction is treated as being stateless. Now, what happens in that context? That's our basic operating framework for the allocation of profits to permanent establishments. What happens in the case where you have an exemption regime versus a branch, an exemption of a PE exemption regime versus a taxable PE, a PE that's taxable under the rules of the head office jurisdiction? Well, in that case, you can create distortions in the context of a loss in the PE. And what we wanted to, and I go back to the notion of the need for an ecumenical and a broadly accepted framework for taxing permanent establishments. And we did not, in the context of a minimum tax, want to create some kind of systemic bias against taxable PE regimes. That would have been an unfortunate outcome from the rules. So we needed to build in a modification that allowed effectively, that respected the outcomes under a branch rate and under a taxable branch regime, provided they worked as intended. So we have Article 345 of the model rules, and what that allows you to do in the context of a branch loss. It allows the main entity to take into account that branch loss, even though that income was allocated to another jurisdiction, to bring it into account under the rules of the main entity in order to avoid having an artificially low effective tax rate in the main entity or the head office jurisdiction as a result of that loss being recognized for local tax purposes. And correspondingly, when there is income in the PE, the income also then gets shifted into the main entity jurisdiction, and that's consistent with the notion of double inclusion income, which is the idea that was developed pursuant to the Action 2 report in the context of hybrid mismatches. So what happens is subsequently when the income comes into PE, we also shift the income up to the main entity jurisdiction in order to make sure that we achieve a level outcome between taxable and non-taxable jurisdictions in relation to branches. Finally, then, some very simple, quick observations. So under Pillar 1, we have eliminated effectively the nexus requirements in relation to Mount A, and what we're doing is now allocating a portion of global profits based on a formulaic destination-based approach. So that will make Philip happy, I'm sure. Combined with a double tax relief mechanism that will allow us to plug those outcomes back into the existing system. In relation to Pillar 2, we have a minimum taxation based on an effective tax rate, base rate, but we are trying to be as ecumenical as possible as to tax policy design choices in each jurisdiction, as well as not making calls about where that income should be located, but rather trying to follow where the income goes and then determine its effective tax rate. So we follow local tax rules, but when we incorporate in certain adjustments to preserve neutrality between certain regimes. That concludes my presentation. Thank you very much for inviting me along to share those thoughts with you. I hope they have been useful, and I wish you all the best for the rest of your conference.
Thanks very much, John, also for saving 5 minutes. Now we are surprisingly ahead of time. But there are certainly many things that we can discuss about. And as I mentioned before, the idea is that this session will now continue in the form of a panel discussion. John is certainly welcome to make comments if he wants to, but the idea is that we have some input from the three colleagues who are here with me on the panel, and then we will have some kind of discussion among them. I will also be making some comments, and then, there might be space also for getting some questions from the floor at the end of the session. I think it's time to present the colleagues who are here with me on the panel. Mario Tenore needs no presentation just because he has already been speaking before, but I would like then to present Giacomo Soldani, who works for Essilor Luxottica SA, and Alan McLean, business at OECD BIAC. The idea is that each one of them will be presenting some relevant issues. As I said, the focus is, well, we've got this concept of permanent establishment. We need to discuss whether we should keep it, and if we should keep it, how should we keep it? And if we should get rid of that, why should we get rid of that? And what solutions could be addressed also within the framework that concerns the two pillars that John has addressed during his keynote speech. Now, I think that what I could gather from John's presentation is that when he mentioned about the ongoing work on Pillar 1, the complexity remains. And that is something which has dissuaded a number of global players from making a commitment to support Pillar 1. Now, we know that John has mentioned that the ones who commit to Pillar 1 will have to give up all sorts of digital services tax. And of course, we are, that is something which is a deal, because on the one hand, you get the recognition of the entitlement of the so-called market jurisdiction to get a part of the excess profit, and on the other hand, you should give something in return, and that is something which will, remove those elements that have to some extent created a bias as to the way in which multinational enterprises operate. But the complexity is something that can be handled by some countries better than by others. So this is something quite important because John mentioned that there is a multilateral convention on its way, and of course, Pillar 1 cannot work without a multilateral convention. It requires consensus, but then it's actually also important to understand whether there will be a world of Pillar 1 contracting states and the rest of the world which has some reluctance to embark in this direction. This is something which, at the end of the day, will be discussed by countries taking into account their priorities in international tax policy. And at the same time, the fact that there is a threshold is also warning us that there will still be a world beyond Pillar 1, also for the states, for the contracting states of Pillar 1. Now, John mentioned also that the threshold will be reduced. But one of the points which you hear from time to time around the world is also, are market jurisdictions really gaining from signing off the deal with on Pillar 1? Some countries are making the point, and I've heard at several conferences also, that the levying of withholding taxes could be something more meaningful from the perspective of other countries. And I've also heard that the Article 12b of the UN Model Convention is an option that is preferable for several countries. We at the IBFD have conducted a study on this recently in summer 2023, and we keep working on this topic. The idea is really that it's important to understand in what direction we are going, and we also expect this conference to provide a meaningful contribution. Now, those are some of the comments that I had on Pillar 1, and I'm not trying to warm up my colleagues here with the panel because they have already prepared some specific inputs, but the idea is also that we can have a sort of interactive presentation, interactive session, otherwise it gets too boring, or we might hear things that we are already familiar with, and this is not why you're here for. On Pillar 2, I think that it's also interesting to see that John has described various scenarios in which complexities arise from the perspective of the levying of Pillar 2. Pillar 2 for us in Europe is already something concrete because of its implementation in the EU GMT directive. But one important point when we look at the scenarios that John has depicted, and the fact also that John has admitted that there might be a bias in connection with the treatment of losses towards exemption regimes, is that meanwhile Some countries are acting, while waiting for the two-pillar solutions to become concrete everywhere. Some countries have already acted and have already introduced some measures which are applicable. And those measures are applicable also in the presence of treaties. And of course, in the treaties, we find the concept of permanent establishment. So we've got to do something about that, unless we opt for introducing a separate clause that does away from permanent establishment. And I mentioned the case of Article 12b. Now, when Mario and I were actually thinking about this little reshuffling of the session, and Mario's been so kind to change his role from co-coordinator into panelist, we have thought that because this conference is in Italy, we also want to bring a little bit of Italian flavor, of additional Italian flavor, because Giacomo Soldani has already made, prepared an input on this. So we thought that it could be meaningful to address the way in which some countries might be trying to work on the concept of permanent establishment. Yes, because at the end of the day, this conference is on permanent establishment, and the future, actually the trends also. So Mario will be soon presenting an input on the Italian solution towards a significant economic presence, permanent establishment, or a digital PE, and the issues which have been arising in practice. Of course, the characteristic or the typical feature of this group is that it brings academia together with practice. So I think that this is an excellent opportunity now to hear from Mario. And then, of course, as I mentioned before, Giacomo and Alan and myself, will be happy also to see whether some comments can be made in that respect. So Mario, now it's 9:58. And you have the floor for the next 10 minutes.
Thank you very much. So I just would like to make some brief comments. I would like to connect with the intervention from John Peterson. I think we can all share the view that we will be facing with the application of very complex rules. At the same time, I believe we are still facing a situation of legal uncertainty. We have the old-fashioned concept of permanent establishment. Philip Baker mentioned it's been there for over 100 years, and now we are trying to adapt this old-fashioned concept to the change in the business. So we mentioned several times digitalized supplies. We mentioned already online marketplace business. So I would like here to bring the view from an Italian tax perspective, how Italy reacted unilaterally to this rising challenge. So in the budget law of 2018, the domestic definition of permanent establishment was amended, and the specific subparagraph in Article 162 of the Domestic Tax Code was added to deal with taxation of digital economy. So we do have a digital PE concept. How the digital PE concept was shaped essentially through an expansion of the positive list of permanent establishments that we have in our domestic tax code, according to which PE is deemed to exist where a foreign enterprise has a significant and continuous economic presence in the territory of the state, and this is a fundamental part of the new provision, the presence has been set up in such a way that it does not result in a physical presence on the Italian territory. So essentially there is a PE in case of otherwise insufficient physical presence. The application and interpretation in practice of this new definition has been, and is at the moment, still quite controversial. There is controversy as to the function of the provision that was introduced with the Budget Law 2018. And let's say we can identify two different positions. So the first position is that by the amendment of the PE domestic definition, the legislator meant to introduce a new PE nexus, which is different and alternative to the traditional PEs, the material PE, and the agency PE. The alternative position, which is the one apparently favored by prominent scholars, is that this is not a new PE nexus, but this is merely the introduction of a specific anti-avoidance clause that is indeed aimed at countering strategies in which the existence of a physical PE would otherwise be found in practice. The position I tend to favor, based on the wording of the provision and based on the case law of the Supreme Courts, that despite not with respect to this specific provision already dealt with the concept of permanent establishment in landmark cases, to mention one, the famous Philip Morris case, is that the provision should have an anti-avoidance function. And this is particularly important, so it's not a mere theoretical dissertation whether it's a new PE nexus or it's a provision with a specific anti-avoidance function. Because if we take the first position, of course, the domestic provision would then clash with the application of existing treaties, if any. And the old-fashioned PE definition, which is contained in Italian tax treaties, would override and prevail over the application of the domestic provision. On the other hand, if the provision has an anti-avoidance function, relying on the position of the Italian Supreme Court, I think the position could also display effects in treaty situations where the Supreme Court has already held that the application of domestic anti-avoidance rules and principles, which are tacitly, let's say, allowed, override the treaty application. So we are at the moment in a situation which is one of legal uncertainty, at least as far as the specific notion of permanent establishment is concerned, with all the terrific consequences that this may display in practice in terms of claims regarding the existence of a hidden PE, in terms of administrative penalties. So to mention, for non-Italian penalties in case of a hidden PE claim may range from a minimum of 120% up to a maximum of 240%. And of course, not to forget also the possibility of criminal consequences. So I don't know if my time is expired, or if you know, we want to leave some time for comments.
It's 10:06, so it's a sharp 10 minutes, and we might have some comments, and I'm happy to break the ice unless Giacomo or Alan want to go first.
Factor the comments in the speech.
Okay, so you will factor the comments in the speech. So I do have some comments, Mario. It's of course a privilege for me to have this opportunity I think, we've got to understand whether the current treaty dimension will stay like this forever. So in other words, we say that there is a fixed place of business, but we have said so far like a mantra that the fixed place of business implies a fixed physical place. But we know that we cannot go for ring-fenced solutions, and we know that business has remarkably changed. So business could be conducted anywhere, from anywhere to anywhere. This solution by the Italian 2018 reform has introduced some kind of mechanism, as you call it, a hidden PE. But are we really hiding the existence of a PE? We're just changing the business model. So instead of having the physical presence, we are having a non-physical presence. But at the end of the day, there is a significant economic presence on the territory of a country. And also, what John said before, with Pillar 1, there is now a recognition of the entitlement of what we can call the market jurisdiction to a part of the profit. So, I understand you have been nicely putting forward the two alternative views that exist in this respect. And of course, I also have a lot of sympathy for the second view, because at the end of the day, if you don't go for the second view, then you have a problem of consistency with the treaty. And therefore, you should say, well, in the presence of a treaty, then I cannot say that my domestic concept of permanent establishment can survive, because it will be, clashing with the treaty. But still, the fact that we, let's say, have been forced to opt for the anti-avoidance route, so saying that there might have been a hidden PE, was something perhaps necessitated. But at the same time, I think that, what I also expect from this conference is understanding what are the margins for reconsidering the concept of PE, and whether fixed place of business must absolutely mean a physical place of business. If we write in a treaty fixed place of business, do we mean a physical place, or do we mean a place which is some more, immaterial? So this is because the economy has changed, and I like to see at the level of interpretation, the commentary of the model is not the Bible, it can be changed, but to change treaties takes longer, and also to go for solutions that will not be accepted by all countries might not achieve the consensus that we are expecting. So whether, in fact, we could, to some extent, make a step forward in this direction. I understand that I've been a bit long, 3 minutes, those comments took me, but I do not know, Mario, if you have a spontaneous reaction and if Alan wants to chip in.
No, I do have a spontaneous reaction, but I will keep it for the last panel. So whether and in particular, whether if we construe the interpretation of this new provision as meant to be a provision with an anti-avoidance function, whether and to what extent we may even apply this provision beyond the digital sector. So the provision was meant to cover the issue of a hidden PE in the digital business, in the digitalized supply case, and so on and so forth. But whether in a tax audit we may consider this provision applicable beyond that issue.
Good, Mario. Okay, Alan, do you want to chip in?
Just briefly on that point, I'm not so familiar with those recent developments in Italian jurisprudence and approach to the significant economic presence. But what it tells me is that countries are determined to tax profits of multinationals in the way that they believe they ought to be taxed. Yeah, and they're coming up with innovative approaches to do that. Significant economic presence in itself is an innovative approach to doing that. And then they find themselves faced with problems or potential problems in the context of existing treaty obligations. And they then look to find ways to ensure that what they want to achieve can stand the test of those treaty obligations. And what that tells me is that the work that we're seeing the OECD attempting to do, which is to prevent exactly that to determine that there is some recognition that profits of multinationals have to be taxed differently from what they are, that we do not have the instruments in our toolbox at the moment to do that, and therefore we're going to introduce something new. In the OECD case, we get Pillar 1 and Pillar 2. But whether those will achieve what they're trying to do, which is to then prevent alternative mechanisms being introduced on a unilateral or a disjointed basis, I think it's difficult to see how we'll get there. Yeah? And therefore, I think that the stability that we had as a business community had hoped for from the two-pillar package is nothing more than a dream. Huh?
Thanks very much, Alan. And I think that this is, let's say, a good interaction within the panel. So I hope that Giacomo is ready to go and kick in with his own panel presentation. So now it's 10:12.
Thank you, Pasquale. Thank you all for the invitation. Let me say that I would like to start making a bit of a history to understand the future trends. And I would start saying that today I definitely have understood why young people, they don't want to have a career in tax. That is becoming very, very clear. You know, we have heard Philip, we are dealing with PE issues since 20 years. It doesn't work, okay? We have heard John, policymakers, how they are struggling in this complexity world. And we have Mario, penalties may reach 240%. If you tell someone, you know, in other countries about this size of penalties, it's really unbelievable. And I'm gonna tell you how, you know, I would like to focus on recent trends. So I'm looking forward from a business perspective, how worried I am, you know, to comply with this complexity and to the cost of compliance of this complexity. But to understand the future trends, allow me to go back 20 years. 20 years, by the way, for those who are Italians, in these hotels, we were having a lot of tax conferences. And at that time, those tax conferences were not about complexity, worried, the cost. Were about, you know, good solution for business with a very proactive way where, you know, it was the era of the tax planning. So the legislation was poor and the business was very complex, you know, form over substance. And was very nice period, and that's why young people, you know, started to do this job. Now, we have to say that after that era was the era of poor legislation and tax opinion. Let me simplify it. We entered in a different era, which was quite interesting because on one side, the legislation developed and became more complex. Anti-avoidance, anti-abuse legislation, CFC rules. And I would say the reaction from the company, let me say for the good taxpayer, was not to fight against this complexity, but was the opposite. The good taxpayer, instead, in moving from complex structure to simple structure to make sure you comply with the increase of the complexity of the legislation, and we adopt as a business, or most of them, transparency. We wanted, okay, the legislation is becoming so complex, then I become transparent. And we have done in two ways. Specific actions. I ask for a ruling, you know, instead of tax opinion. Now, also tax consultant, they say better to go for a ruling, right? So we always go for a ruling. We go for bilateral APA. We go for APA, so we get certainty on specific transaction. So we become more partner with tax authority. And on the other side, same importance, we are all keen to cooperative compliance regime. So again, transparency. Is too difficult the legislation? Okay, we understand the purpose of the legislation and we go into the cooperative compliance regime in Italy. We go to the relation de confiance regime in France. We go to the horizontal monitoring regime in the Netherlands. And this is where we are so far. Now, it was very interesting, the title of this conference, Recent Trends. So when I started to talk, to think about what can I say, I'm not an expert on technical details of PE, so I said I would like to focus on trends. And thinking about the recent developments of the legislation, I think that with the Pillar 2, this era of transparency is over. It's going to be over, because Pillar 2 does something that I've never seen before. Pillar 2, first, let me say, they have some features that may change completely also the business approach that we have done so far. First, complexity. You know, all tax people are used to complexity, but Pillar 2, if you link complexity to cost, it's something, I don't know, at the OECD level. I mean, normal multinational company, 1,000 legal entity, okay, 1,000 legal entity. If, I don't believe it's going to happen, otherwise I will retire, but if the safe harbor rules will disappear, okay, I have to run a calculation for 5,000 legal entities, plus the company I have sold, maybe, or the company I have acquired. And for certain items, the deferred tax, I have to look 4 years, 5 years back, 5,000 financial statements to be analyzed. This is a problem for a business perspective, but it's going to be a problem also for tax authority. Is that realistic that in the future someone is going to check 5,000 statutory financial statements and make a reclassification? So the complexity and the cost of Pillar 2 is going to change the business perspective. Then there is some other issue which are frustrating to a certain extent. If I understand well, but honestly, you know, I'm for sure not an expert, but transfer pricing, you may be taxed, but you are talking about the income of your business in a group. Pillar 2 may raise taxation for something that has been done from someone else, you know, on a different complete business. And I will make an example. And on top of that, I haven't seen any comment talking about Pillar 2 with respect to corporate law, like minority shareholder, where, you know, this taxation is coming in under certain situation. A minority shareholder can be hit by this taxation. Let me try to make one example to focus on those, let's say, strange effect of Pillar 2, but also collateral effect of Pillar 2, where you don't have to look only to tax. You have to look to the corporate law. You have to look to when information is price sensitive, is privileged. So you have to deal with a lot of things when you exchange information. Assuming we have an UPE, an holding company, that has more than 30% of a POPE, which is listed. Okay, so the POPE has his minority shareholder. Now, the POPE may have, in a non-Pillar 2 state, a subsidiary, okay, 100% with a nice tax rate at 20%. So, no impact. If the UPE, who is, you know, just doing the consolidation financial statement, but is a shareholder at 30%, create a business in the same non-Pillar 2 state, where you have also the subsidiary of the POPE, and this business, assuming is running at 0% tax, what is going to happen? It's going to happen that we put together the two companies in the no-pillar tax, we calculate the total tax, and we split, meaning that the minority shareholder of the listed POPE are going to pay a tax because one of the shareholders has created a business with a tax incentive. That is for me crazy from a principle. You know, Pillar 2 is breaking a wall that I have never seen in the history. You are taxed for someone who is doing something else in a different business with a profit that is not related to you. Second, and this is the interesting question, assuming I am in the case, I'm not, but assuming I am in the case, and then I go to my shareholders meeting, and then the minority shareholders may say, guys, we have a taxation. You have to charge your UPE, but I cannot do. How can I charge? There is no legal ground to recharge the UPE. And this may create a big difference for the future, because for those who set up now a business, or who set up now a joint venture, they may introduce clause, no? For the newcomers, they may introduce clause, and we are already doing, when you do a joint venture, and you may think that certain activity may create tax for you, you can protect yourself for the future with clause to say that in this situation, if my shareholder is going to do this, I'm going to charge you. And then you solve the problem with the minority shareholder. But this is only for the future. In the past, what we are going to do? Are we going to face issue with minority shareholders? So this is one example of, I think, what is coming in the future. I don't know how I am with the time.
It's 10:22.
Perfect. So, and that is really worrying from a business perspective. So just to conclude, again, today I finally understood why young people don't want to take this career in tax, because we have only complexity and a lot of worries for the future. Thanks.
Thanks very much. Yeah, thanks very much, Giacomo. We should not forget that we talk about Pillar 2, we call it Pillar 2, but we should call it the EU GMT directive. And this is, why do I make the difference? Because member states of the European Union have simply no leeway. They have to fully implement the directive. So we have complexity. We cannot do anything about the complexity. The directive is super detailed. And, you know, we're now implementing in this country this directive. No leeway. There is not much we can do about it. That's it. So, you know, this is something which, I mean, Giacomo is bringing the perspective of business and the concern about the complexity, and also the nice example about minority shareholders and the ones that have already embarked in some activities and then end up seeing this obstacle. There is really not much that we can do about it. Plus, the EU GMT directive is also having the QDMTT on an optional basis, so it brings additional uncertainty. It's not that we have hyper-complexity with total certainty, we have hyper-complexity with a degree of uncertainty. Not much we can do about it, but this is it. So I do not know if Alan or Mario have some comments.
No, I have no comments on your intervention. I think I have a question, which is more a curiosity. So, you have an in-house role. So, in this world of legal uncertainty, how much you consider crucial the availability in the jurisdictions where you operate of a specific program as the one you mentioned? So how fundamental is for a multinational entity to rely on the existence of those programs locally in order to get legal certainty, possibly in advance, regarding the existence of a permanent establishment? Yeah, like cooperative compliance or the...
No, this is key for me. This is key because, you know, we look for all programs, this kind of program of cooperative compliance, because in a company where, you know, the business is first, so tax has to support the business. In this context, tax management is required to support, to avoid bad surprise for the future. So whatever can be done to get certainty on the taxation is very welcome. So exactly, so on PE, whatever possible, can click clarify in advance, and sometimes not always with the ruling. So having a discussion within the context of this cooperative compliance program is absolutely key. And this is also key because if we go then to Italy, for instance, as you know, in countries where you can have also criminal aspects, the disclosure make a difference. I remember in Italy, I don't know if it's still valid, maybe not, because now it's not criminal anymore, but when transfer pricing was criminal, there was an article in the Italian code saying that if you disclose your method in the financial statement, then you don't get the criminal aspects, right? So the principle is always disclose, that you always help. I don't know if I replied.
Thank you, Giacomo. Alan, you have any follow-up comments?
Yeah, just a couple of reflections on that, Giacomo, and thank you for it. The first one is about this change in this kind of broader trend away from cooperative compliance, away from transparency, and into something which is yet to emerge, which we don't know what it is, but perhaps a return to the past where companies were not involved in those kind of relationships. And it appears to me that, if I take that together with what John was saying about the need for complexity, or complexity having arisen as a result of compromises that have had to be made, at the heart of those compromises, or perhaps underlying those compromises, for me, is a sense of a lack of trust. Yeah? So some of the things that we're seeing in the rules for Pillar 1 and Pillar 2, for me, are examples of a lack of trust, yeah, from the part of the tax policymakers with respect to companies, and that's why it has had to become so complex. That's why we haven't been able to have simple apportionment rules, simple sourcing rules, because everybody sees the possibility of exploitation, yeah, by companies. So perhaps that sort of very brief golden period that we've had, maybe not comprehensively or universally, of trust-based relationships between taxpayers and tax authorities may come to an end, partly as a result of the uncertainties and the complexities which have arisen. It may also be possible, as I think also Giacomo said, that those things become even more important, yeah? And maybe, in fact, we have more certainty processes that are outside the official certainty processes that we've seen within the design of Pillar 1 and Pillar 2, because companies, I'm now here representing business at OECD, but up until April this year, I was the head of tax at Shell. We don't know how to comply, no? And the guidance continues to emerge about how these rules are supposed to be applied. And in that continuing state of development, we have to prepare our financial statements, and those have to be accurate, and we have to have provided accurately for these taxes which are still uncertain, and that creates enormous problems, I think, and enormous concerns for many tax directors. So I'll stop there, and I think that's compounded, I think, in the context of the GMT directive, a directive that was cast in stone before the rules themselves had finished developing.
Yeah. Thanks very much, Alan. I think that what we bring home from Giacomo's presentation is the importance of cooperative compliance. I think we can also reasonably say that there is growing awareness of this importance, growing awareness of anticipating the debate between large multinational enterprises and the revenue because of the complexity of the rules. And of course, this is something which which we'll see how much it will further pick up, including in this country, where we are experiencing a potential development of this. Now, it's 10:29. I understand that there might be people in the room who want to make questions. Now it's 10:30. I just think that it could be meaningful for you to raise your hands. There have been already 4 hands raised, if I understand correctly, Paolo, Andres, Svietislav, and Vikram. But we will take those questions at the end, because I want to make sure that also Alan has his 10 minutes. And then, we will have your questions. Alan, it's now 10:30. Please go ahead.
Okay, I will try to simplify what I was proposing to say.
No. You have your 10 minutes, so you are equal rights.
Well, indeed. So first of all, thank you for this opportunity to speak and to contribute on these important topics. I was going to focus largely on the way that business and business at OECD had responded to some of these developments from the OECD, with a particular focus on Pillar 1 and Pillar 2. For those of you who don't know, business at OECD, formerly known as BIAC, is the official institutional advisor to the OECD of business. It's made up of a large number of companies and business organizations from the OECD countries. Yeah? So we have a tax committee which has many representatives from a wide range of sectors. And as you can probably imagine, in trying to respond to these highly innovative, highly complex, and highly disruptive new developments from the OECD, that finding consensus within the business community has not always been very straightforward. And of course, that's because many of our members are differently impacted by the various proposals. But I would say that, that these recent trends and developments are as capsulated to some extent in the developments in Pillar 1 and Pillar 2, are of course just the end of a very long line of developments, unilateral developments, collective developments by countries to try to deal with a business world which is entirely different from the business world that was in their mind when the current international tax system in particular was established. And that, I think, led to a state of confusion, uncertainty, controversy, and therefore business at OECD, when we were told that a new package of measures would be introduced, first of all through BEPS 1, and then of course importantly through and most recently through BEPS 2, that would eliminate that confusion, that would bring certainty and would eliminate controversy in the world of international tax as it applied to modern business models. And I don't just restrict that to concepts of digitalized business, but to modern business models generally. Then we were very much we were very positive about that because we thought that we would get clarity, certainty, and simplicity. Well, fast forward to today, you saw the presentation that John gave, which is a very high level and highly simplified description of how Amount A of Pillar 1 would apply. And I think it's clear to all of us that we are very far away from simplicity, we're very far away from certainty, and all we have is a lot of complexity, and many of us don't know quite how best to approach that. I mean, so on Amount A, for example, BIAC has many concerns about the way that it might work. Many concerns about the sourcing rules in particular, many concerns about whether or not double taxation that might arise will actually be effectively eliminated through the processes which have been designed in the rules of Amount A, and simple things like the treatment of withholding taxes and so on and so forth. So these remaining questions that to some extent undermine the agreement that we had in principle to set aside the arm's length principle in favor of formula apportionment on a limited scale, albeit, begin, I think, for many people to raise the question of whether or not that's what we're going to get. Of course, we still to see the MLC. We understand that it might run to hundreds of pages to capture some of the complexity of the rules in Amount A. And therefore, I think there are a number of people who were really asking the question of whether or not this will resolve once and for all the problems which the existing system or pre-existing system had. On Amount B, again, this was proposed to business as the thing that would be the sort of the silver lining on the dark cloud of Amount A, something that we would welcome. Business at OECD, in our most recent contribution to the public consultation on that, have said that we believe that the scope is too limited, that we see very little justification for the variety of approaches in the pricing matrix that we're expected to apply, and point to the considerable complexity, even in something which is supposed to be a simplification measure and one which is supposed to provide greater certainty. We also, of course, in the context of Pillar 2, have the new subject to tax rule, and that's a rule that will allow developing countries, or those developing countries that sign up to it, to impose an additional tax on many and a wide range of cross-border payments where the recipient country doesn't tax those at a rate of at least 9%. And finally, before I conclude, this week we saw some developments in the work that the OECD is taking forward in the context of mobile employees. And I know that you have previously had a conference on that subject in its entirety. And there was a surprising disconnect there between the delegates there, the policy delegates, who felt that it was unlikely that any tax authority would launch or would seek to assert a permanent establishment based on the use of a home office by somebody who's not in the jurisdiction of their employing country. And that was on the one hand from the tax authorities, from the tax policy people themselves, and we contrasted that with the real life experience that many of us are having, that in even the most minute cases that tax authorities are indeed making those assertions and trying to attribute significant amounts of profit. So you take all of that together and you see a world which continues to be highly uncertain, highly unstable, highly dynamic, and I think that it's still, and the jury's still out on how many countries will sign up to the MLC when they finally see it, and whether amount A will become a permanent, or at least in the short term, a permanent feature of our international tax regime. It's hard to see whether this complex tapestry or patchwork of approaches that seem to be designed to achieve outcomes that have been set a priori will actually achieve that, and whether alternatively we're going to continue to see the emergence of new policy approaches, but also more new administrative approaches that have a particular predetermined end in sight. Thank you.
Thanks very much, Alan. We have 8 more minutes to go. I have a very short comment. Alan mentioned the Home Office, and I think that this session would be incomplete without a mention of the Home Office issues. And I think it's quite important that we understand that Home Office is something which is becoming more and more normal, and it's something which cannot be predicted in advance, except when you have a contractual right to work from the Home Office. But even if you have that contractual right to work from the Home Office, the issue arises to whether you in fact work from the Home Office. So these are quite important issues. The place of business shouldn't be one, could be several. It is immaterial how this concretely shows up. But still, it's important that when we talk, there is a lot of talk on the Home Office. But then, we cannot think that because a secretary works from the Home Office in a different country than a company has a PE. We cannot have a mushrooming of PEs because of the fact that there is flexibility with working contracts. Of course, a secretary is one thing, and somebody is in a leading position is something else. So I think, we've got to take a cautious approach in respect of Home Office. We have to be open and understand that when there is a place available, and if in that place, some functions are taken or are exercised on a regular basis, then there should be some consequences, but also we should avoid a mushrooming of those Home Offices. Now it's 10:39. So we still have 6 minutes for 4 questions. And I saw that Paolo was the first one to raise his hand, but maybe I'm wrong. Maybe I was looking this direction. But anyway, we've got the four musketeers anyway. So it's. But don't waste seconds.
I'm generally the watchdog, but with Pasquale it's difficult to do it. My question is the following. Do you think, it's a question for Mario, do you think that what Pasquale proposed as a policy switch in the evolutionary interpretation of place might be a viable solution, also having regard to the need that we have in this period for legal certainty? Because we are seeing that legal certainty is probably a value that right now is not at the top of the money.
Question is clear. Mario, keep it on hold. Next one, Andres. Andres Baez.
Thank you. I've got 2 questions. I don't know whether John Patterson is still there, but maybe Alan may respond to this. Is there already a decision on the withholding taxes and double counting for Amount A purposes? Because if they are discounted, then I fear that maybe Amount A is something that nobody will like, neither the US nor developing countries. So the OECD may come out doing something that nobody likes at all. The other question, and maybe this would need more time to be developed, but this new concept in Italy, and of course I haven't read the provision, pretty sounds to me like kind of a diverted profit tax. Isn't that just a way to force multinationals to sit down at a table and say, you have a portion here, that's it? And well, I have just learned that that Italy has not ratified yet the MLI, but would Italy ratify the MLI? Would this kind of domestic anti-avoidance measures, if they are in fact that, be compatible with the PPT treaties? Thanks.
All very clear. Next one, Svetislav Kostic.
Thank you. I have a question for Giacomo and Alan. From the perspective of the complexity that is involved in that you, Giacomo, especially spoke about, is there potentially a danger if we implement Pillar 1 rules that companies would actually go for cutting certain countries off the market, not doing business at all because they don't want to incur the compliance costs and the complexity involved? Because I'm just thinking about, for example, a small African market wherein in order to meet your obligations, you would need to set up local bank accounts, both in the foreign currency and domestic currency, because you would need to pay tax locally. And with all these complexity, if the 250,000 euro threshold is there, would it actually make more sense for a company, especially a digital one, to cut off the market, which in this digital age could actually have a sanction-like effect and actually be more detrimental for the development of the economy of that country? So, I mean, is there a danger of that happening? What do you think? Thank you.
Giacomo, is the question clear? Yes, okay. So keep it on hold. Vikram Chand.
Sorry, I don't know if John Peterson is still there, or probably Alan, you can take this question because
I'm not in a position. I cannot tell whether he's still there because I don't see.
Alan can take this question. Do you have any insights on what we can expect in the next round of administrative guidance on Pillar 2, and the equivalent which has been implemented in the EU? So that would be nice if we can get some insights of what we can actually expect or taxpayers can expect in the next round of administrative guidance.
Okay, thank you. Now we have some little time for the replies, which are essentially by Mario, because I need to get some signals if John is still there, because so we will not be able to answer a couple of questions, namely one by Andres and the one by Vikram. Mario, do you have any possibility to reply to Paolo and
evolutionary concept of
maybe also to Andres?
Yes, of place of business. I think with home office, the crucial issue is apart from the definition and the notional concept of PE, also the allocation of profits to the home office. That's something which I think has been left a bit behind, but I think both issues should be let's say, investigated on a parallel basis, because several times we may even conclude that in cases, as you mentioned, there is a home office, but what would be the profits concretely attributable to that PE? It's a big question mark. With respect to Andres, I think the question you raised is a fundamental question that would deserve possibly a separate session. Well, I think so far, as you correctly pointed out, Italy has not yet ratified the MLI. It will soon, so we expect it will apply in the near future. As far as your question is concerned on the compatibility with the PPT and the new concept of domestic digital PE, I think if we take the approach that the new provision is meant to introduce an anti-avoidance tool, then I see potentially also a room to apply the domestic provision in a treaty concept. And I don't see a clash with the PPT once the MLI will be introduced. But I think this is certainly a topic that deserves much deeper analysis.
Thanks very much. Final word for Giacomo.
Yes, no, question was
microphone.
Small businesses, cost of compliance. Let me say, I see more, especially when the numbers are not big, I see more the risk of being non-compliant than going out of, that stop the business. Because if the risk is limited, You may be there for a business reason, you may be there for catching new opportunity in the markets in the future. So if the business want to stay there, we will make the cost of sustainable to a certain extent.
Okay, 10:46. This session is over. Thanks very much to our panelists.
Thank you.